Okay, we are started and we are recording. Give attendees a chance to show up, but in the meantime, I will take roll, such as it is. Hartston. Here. Sarush. Here. Great, so we have our full subcommittee. This is the meeting of the Regulation Subcommittee of the Paraprofessional Program Working Group. I want to see if we have anyone who wants to make public comment. We have a few people who are in attendance. If you'd like to make public comment, you can use the hand raising function in Zoom. Give people a moment to do that. Doesn't look like there's any interest in public comment. Thanks, Amos and Fariba, for putting all that time into drafting those documents. And we do have a couple of guests. I don't know if you want to introduce them.
Sure. And I'll have you all introduce yourselves, but thank you so much for joining us today. Chris Sturdivant. I don't see your face. And Chris and I have spoken about bonds, and I look forward to Amos and Fariba, you being able to get all your questions answered. And I know Chris invited you, Bill. So maybe you two can briefly introduce yourselves, and we'll start with the bond issues and questions.
Thank you. I am Bill Anderson. I'm Vice President of Government Affairs at the NNA. I work alongside with Chris, and like Chris, I am a California insurance broker agent that transacts insurance in the state of California, as well as licensed in all other states.
Can you tell us what the acronym stands for?
NNA stands for National Notary Association.
Okay, great, thank you.
Hi, and I'm Chris Sturdivant. I'm the Vice President of Business Development for the National Notary Association. And I also head up our business development efforts for NNASuretyBonds.com. And I'm a licensed insurance agent in all 50 states.
All right, so Chris was referred to me, Fariba and Amos, by Elizabeth on our working group because of the connection with LDAs and providing bonds for LDAs. So we had an initial conversation, and I don't know, Linda, if any of your slides speak to some of the questions that we continue to have about how bonds work, because of course, we don't require bonds in our attorney licensing scheme. And so we are not very familiar. I know, Amos, you have more familiarity, but really just wanted to provide an opportunity to dig into what bonds do and do not cover, how claims against bonds are made, if there is any data that would enable us to determine the frequency with which a claim is successfully made, claims are paid out. So those are some of the questions that we have. Amos, Fariba, do you want to jump in, or would you like Bill or Chris to start off just with the general overview? What would be best from your perspectives?
A general overview, in my opinion, would be helpful. And then I have the same questions you just presented. I basically am interested in, if this is for consumer protection, how difficult or easy is it going to be for a client to be able to collect, basically be reimbursed, correct the funds they spent or they lost, due to the malpractice of or bad work done by paraprofessional.
That sounds great to me as well. Thank you and welcome.
Yeah, so this is Chris. I'll just kind of briefly share, I guess, what a surety bond is. And I'm going to turn it over to Bill, because Bill has a pretty substantial expertise in handling the bond claims that we've experienced at the National Notary Association over the years. So I think he'll have some pretty good insight into the claims process, what typically makes up a claim, and maybe even have some general ideas in terms of what loss ratios to expect. Basically, a bond does not protect the individual professional. A bond is there to protect the public. So it's actually a liability to the professional. If there's a claim against the bonding company will seek reimbursement from the actual professional. So it's a financial guarantee that's required typically by licensing entities, typically government agencies or entities, and it's there to provide some financial wherewithal in the event that the professional is unable to make good on a judgment or default. So typically with a surety bond, rather than requiring the professional to have to post a certain amount of money with the licensing body, they're able to just purchase a bond for a fraction of that cost from an insurance carrier, and that insurance company provides that financial guarantee. So it's a low-cost way for the professional to have some financial skin in the game. That being said, I'm going to go ahead and turn it over to Bill and let Bill kind of provide some history on the claims process and kind of some of the things that he's seen over the years.
Yeah, thanks, Chris. Just in addition to what Chris said, a bond is different from, say, an attorney professional liability policy, or even a professional liability policy, an errors and omissions insurance policy that we would sell to our notary customers, because a policy is basically a contract between the insurer and the insured. And the insurer has a duty to defend the insured against a claim or against an allegation of a claim. Whereas a bond, it's really not a contract between the notary or the insured and the insurer. It's a three-party contract. It's between the surety and the individual who is obtaining the bond. It's called the principal. And then what we call the obligee, which is, in this case, the state of California for, let's say, an immigration consultant bond or an LDA bond. And the surety, unlike an insurance policy, is there to defend the bond and not the individual, the principal of the bond. Now, with that said, we at the NNA have been an insurance agency in California dating back to the 1980s. And so our main core business is notary public surety bonds, as well as errors and omissions insurance policies. Since Chris has come on board in the last 10 years or so, we've started to sell a lot more commercial bond policies. And Chris has expertise there. I can just share generally with regard to the claims process with our notary bonds. The claim could be initiated in one or two ways. There could be a lawsuit that names the individual, the notary in this case, or maybe the immigration consultant or the LDA, and the individual gets served with that lawsuit and then notifies the surety of that claim. And that would be important if the surety is not named as a defendant in the case. The other way a claim can be initiated is with what we call a letter claim. And that's when, for example, an attorney contacts a notary and says, hey, I have a client, and we have reason to believe that you performed, you committed an error, and we would like to, access the bond to recover, our losses. And so then the notary would forward that bond on to our surety, which is Merchants Bonding Company of Des Moines, Iowa. And Merchants has a claims department, and they have claims examiners, both on the commercial surety side and on the notary side. And so the claims examiner would examine the claim, and if they feel the claim has merit and that they are obligated under the bond to pay a loss, they'll go ahead and directly pay. Sometimes they'll need to go outside and secure the services of an attorney in the state where the action is being commenced, and have the attorney handle a claim to closure. But they do handle a lot of them inside. And, at least on the notary side, the bond is $15,000. For an immigration consultant, it's $100,000. So there's a great motivation to try to settle these without litigating that. And most of the claims are in fact settled and not litigated.
Can I ask a question about that process for submitting a claim? You said there are 2 ways to do that. And Chris, I thought when we spoke that you indicated that there needed to be a judgment. I just wanted to make sure that we really understand what is required to file a claim. So what I heard you say, Bill, is a lawsuit is filed, and I think you call them the principal comes to you, right? Or you get a letter claim from, I guess, an attorney representing an aggrieved client of your principal. Yeah. Or perhaps from the aggrieved client themselves. Is that possible, or it has to be?
Yes, they can, absolutely. Okay. Because the bond is public. With immigration consultant bonds in California, any member of the public can go on the Secretary of State's website and look up an immigration consultant, and their bonding information would be in the record for that immigration consultant, and they can contact the surety directly. Yep.
The client can also submit a letter claim. No legal action is necessary, right? That's what we just heard. Okay, and then what is this claim examiner? Did you say they're an attorney, or they're kind of like an adjuster, like an insurance?
They would be like an adjuster. I'm not sure how it works on the commercial side of merchants, but the claim examiner on the notary side, to my knowledge, is not an attorney, but they have attorneys there that are in claims, which, review them as well.
Okay.
But the examiner is very good.
Go ahead. I'm so sorry. Go ahead.
No, the examiner is very good
at
what she does, and has been doing this for a number of years.
Okay. And when you say what she does, I'm assuming the investigation would include interviewing the principal, the client, looking at, depending what the claim is, right?
Yes.
Okay.
Yes.
Okay.
Yes.
And then you refer to commercial versus notary. Is commercial like immigration?
Right. Actually, in the surety world, there are a lot of different types of bonds. A notary bond would probably be more properly considered a public official bond. And a commercial surety bond would be, for a tax preparer or for an immigration consultant, someone who is not, a public official or a public officer like a notary is in California.
And what are, one last question, I don't want to hog the time. What is the timeline for, are there mandated guidelines in terms of timelines for a claim examiner to complete their work from the date that for example, letter claim is filed?
Well, gosh, so I guess it all depends on the nature of the situation. We've had claims, if they're open and shut kind of claims, certainly because, the surety is concerned with limiting the exposure of the bond. If they feel they're responsible, they want to pay out as quickly as possible to limit their defense costs. But we've seen notary bond claims go on, under the statute of limitations for 6 years, because the Code of Civil Procedure has a very detailed statute on on the totaling of bonds. They can be anywhere from, in California, 1 to 6 years. They can be settled. You know, and sometimes the matter isn't discovered, you know, and then there's a certain amount of time after discovery that they need to file the bond in order for it to meet the tolling statute. But there's really not a delay on the surety's part. Merchants is very fair. They and very responsible in paying out claims when the merits certainly support them.
And it sounds like there's not the same issue with the bond as there is with errors and omissions insurance. It's not this claims made issue because they're required to maintain the bond.
Yes, that's a good point. Under, you know, an attorney malpractice policy, you know, you have to keep paying on that policy because the claim has to be made while the policy is in force. And if you don't pay the premium, the policy will lapse. And if you retire and, for example, don't have a tail policy, which extends the reporting period out on that policy for however long you can, and you pay for it, then the policy won't be, the claim won't be honored. But it's in the bond world, if you are, for example, a notary, and I'm commissioned for 4 years, I buy that bond, and it's what we call an occurrence, you know, based instrument. If the event occurs within the time the person is covered by that bond, even though the claim might be filed later than that, it will still be covered, if of course it meets the requirements and all.
So Bill and Chris, I assume you have the background of what this subcommittee is looking at. It's looking at a proposed new professional, non-attorney that provides some limited legal advice and trying to figure out what the regulations should look like with respect to financial responsibility. So very interested, you know, if there's both malpractice insurance and a bond. I think there was some confusion about how that would play out if there is a claim. And, you know, obviously we don't think there'd be double recovery, but would one come first? Would that be more protective for the consumer? You know, how does it impact the paraprofessional? So I'd be interested both in a little bit of an understanding of the interactions between assuming both malpractice insurance and a bond is in place. And if you guys have thoughts about a bond requirement for, you know, a new licensed paraprofessional.
Chris, do you have any thoughts?
Yeah, I just need to unmute myself. Yeah, I think that it's probably important to note that there are situations where a professional liability policy or policy will deny a claim. There are many exclusions on those policies, where specifically like fraud, whereas a bond, the financial liability to protect the public doesn't go away in the event of fraud. So in fact, we saw a circumstance in West Virginia, I think it was, Bill, several years ago, where the state allowed the notary professional in that case to purchase either a bond or a professional liability policy. But once they realized that the professional liability policies might cancel in the lack of, if the premium wasn't paid, or also that they didn't pay out in the event of fraud, they changed their requirements and required the bond. So those would be a couple of the significant provisions between the two that I would take a look at. And then Bill, I think, can probably talk more about how the payout piece works in a claim between insurance and a bond.
Yeah, Chris makes a good point about the bond. The bond will cover fraud. And so the policy will typically exclude that. It also will exclude intentional acts and bodily injury and a whole host of other things. the payouts, I mean, I really don't know that I can comment much on that, except to say, I just get the reports every month from merchants about the claim activities, and they're opening and closing files constantly on a given month. I just got the November claim report in today, and there are reserves set for certain bonds and all, and when there's activity on that bond, they have to pay legal fees or they have to pay the direct loss. It's noted, and at the appropriate point, the claim is closed out.
It may be, Amos, if we want to know about how they work together, that we would try talking to somebody at merchants, it sounds like.
Yes, if you want more granular insight into the claims process, as well as getting a take from a surety's perspective, that might be a good idea.
I think the question for us, and I'm not sure how best to answer it, is, I have been pushing for a bond requirement, and as is required of notaries and many other licensed professionals. I think we're coming to some sort of agreement, but I think there's still this open question about malpractice insurance, and we're sort of, I think, trying to sort out, does it make sense to require both? Does it make sense to, pick one or the other? And that sort of interaction where I just don't think we have fully answered understand how they might work together.
Yeah, in the notary world, for example, a California notary would be required to get a $15,000 bond. And then they may optionally obtain another policy, a policy in $25,000, for example, is a common amount. And let's say there's a claim, okay? Of course, the bond is public, but the policy does not get disclosed until discovery. And, the insurer will not necessarily volunteer the information that there's a policy. Now, if the way it would work for the notary is if, let's say, they settle the claim and it's insurable under the policy, and of course, then it would be obviously covered under the bond, they may pay that out of the policy instead of the bond, so that the individual is not prevented from continuing in their licensed profession. Because in some cases, you have to maintain a bond of a certain amount. And if there's claims that reduce it, that may affect whether or not you can continue to practice. So for a notary, having the policy helps to solve the claim in that kind of a manner.
That's really interesting.
Yeah.
And in terms of when you said if it's eligible under the policy, it necessarily will be under the bond. Just to understand, is it like a Venn diagram? You've got your policy here and your bond here and eligible, and then there's some nexus in the middle of claims that are eligible for both? Or is everything that's going to be covered in an EO&O or PLI policy necessarily going to be eligible for a bond claim?
Yeah, if you look at the bond form, and I could send you a sample bond form, you can see that there really are no exclusions on it. It'll basically say it'll cover acts performed as a duly sworn and commissioned notary public. And that's about it. Whereas the policy, it will state the limits of liability. It will state exclusions. There will be conditions precedent, and other, types of language that are in a standard insurance policy. It's a little longer. And it'll essentially, and it's not, in the case of a notary bond, it's not that long. Yeah, it's 2 pages as opposed to the bond being 1 page. And the big difference is the exclusions.
Okay.
And the big part too, Bill, is that the professional is always going to want to use their insurance policy and not have the bond pay it, because they don't have to pay that back if they have the insurance policy. And I think another important point to note too, and because I saw this kind of in my previous life in the mortgage world, is that with a professional liability policy or E&O policy or malpractice policy, you're going to have a difficult time monitoring that those are still in place for your professionals if you're going to mandate that. Whereas the bond, because as Bill talked about earlier, there's three people on the contract, including the obligee. If the bonds are continuous until canceled, so if the professional doesn't pay to renew their bond at the end of their license cycle, the insurance carrier will notify the obligee, the state, that the bond has been canceled. So you do have that cancellation mechanism in place for surety bonds that you won't have in place for insurance policies or malpractice insurance policies, unless you were to require that the insurance policy submitted to you names your organization as a loss payee.
Yeah.
I hope I'm not asking for too many details here, but I'm just trying to understand. So you said notary public bonds are 15,000, for example, and immigration consultants 100,000. In terms of what is paid out, is it? I'm just trying to figure out if a paraprofessional really does bad work and there are multiple clients that file a claim, do they all get paid? Or let's say the bond is for 100,000. I don't know what's going to be, but let's say it's 100,000, and let's say there are 10 people. I mean, just a bad person. 10 people file a letter claim, and the total damage is, I don't know, 150,000. How does that work? What does this $100,000 mean exactly?
Well, that's the maximum amount that the surety is obligated to pay out in losses. Now that wouldn't cover defense costs. So defense costs, are outside of that limited that bond amount. So it might be, $100,000 in losses, but they may have to pay, $50,000 in defense costs, to defend the bond.
I think to answer your question, Fariba, it's not a per claim limit. It's a total limit for the policy. So if there are 3 claims, each one at the maximum amount of the bond doesn't pay more than the max, and it's a first come, first serve. Once the bond is used up, there's no more money that the surety is on the hook for.
For forever or for the year?
Well, for the term of the bond, the immigration consultant bond is a 2-year continuous bond, so that the premium has to get paid every 2 years to keep it up. In the notary bond world, there are some states, I may have alluded to this, California necessarily isn't one, but that will actually require the surety to report claims. And if the bond is reduced, they have statutes which basically by operation of law suspend the commission of the notary until they obtain a bond at the fuller amount. And if they can't obtain a bond because of their claim history, then their commission might be revoked at that point. I think important for your all consideration is, I think the bond is the right vehicle to protect the public here because it's broader. And it's by definition public, and you ought to have a mechanism for how the public can access that bond. Like with notary bonds, in their notary seal, the county where their commission is is filed, mine's in Los Angeles County, well, that's where you would go to find the filed bond that I have recorded. The Secretary of State, with regard to immigration consultants, does that centrally, and so they're the ones that have that information of the bond and make that publicly available. So it's important that the public be able to access that easily and quickly.
I'm trying to figure out why bonds weren't required for attorneys. And like, what is the benefit of malpractice insurance? I'm just I love to hear. Is it that the limits are higher? Is it that we don't know because we don't have claims data on malpractice really either? Is one of them harder for claimants to get paid out on, or easier? You know, how hard is it to access the remedy through bonding or through malpractice insurance? Like, I'm just wondering, based on what you're saying, why didn't we have a bonding requirement for attorneys?
Well, I think that it's, you know, and I'm not an attorney, but at least from what I understand, you know, it's fairly public knowledge that attorneys must have malpractice insurance.
They don't. They don't.
No.
Not in California.
That's what I said.
Well,
I'm an attorney.
All right. Well, then it operates very similar, like a notary policy, where, you know, it becomes a chess game, you know, in a claim. You know, you're not necessarily volunteering that you have a policy.
So,
and the person has to discover it, you know.
And generally speaking, insurance policies are thought to protect the professional. So the idea is it has a duty to defend, and a rational business person may want to not subject their personal assets to judgment and to have a policy that protects them and defends them. And that's a choice. Whereas a bond, I think, is usually a licensed professional that protects the, you know, with the idea that it protects the public. So a different purpose, but, you know, obviously overlapping.
Yeah. Interesting.
Maybe that's the way we should have gone with the attorneys.
That's what I was just thinking, Linda. The whole thing.
Because I think that really is.
The whole thing was wrong. Yeah.
And I think that's the difference, because the insurance is there to protect the insured.
Yeah.
And so if attorneys decide that they don't need it, and what they find is they have other mechanisms to protect their assets.
Well, yeah, or they self-insure. You know?
They self-insure, or they don't, and they basically say, "Go ahead and sue me. My assets are all in protected."
That's the problem, that because there is overlap with what we're talking about for financial responsibility, where the person is basically judgment proof, or they don't have assets, or you sue them and it's not, the paper's not worth the judgment's not worth the paper it's on. So to have some pool of money, that's what a bond is at basic. But a malpractice insurance is also that.
Yeah.
So I have a question in terms of a bond, because one of the issues with a malpractice suit is it's challenging to prove malpractice, and they're highly litigated. So if a malpractice claim is made when there's a bond, what kind of investigation is done there to determine whether it's malpractice and that it's eligible for reimbursement?
Well, I can give a notary claim because that's what I'm most familiar with. You know, with a policy, for example, there was a notary who worked at one of the postal shops, retail postal shops, provide notary services. Somebody came in to have a deed notarized. And you may know that in California, for a deed, a notary must complete a journal entry, an entry in their log, and get the thumbprint of the grantor in their journal. Well, for one reason or another, the individual who was signing the deed got the notary distracted, and there was a lot going on in the shop, and the notary forgot to get the thumbprint. And of course, as things would have it, the individual was an imposter, and you could kind of guess how that played out. That the whole policy got paid out because it was proven very, very clearly that the notary breached their duty of getting the required thumbprint, and that thumbprint is instrumental in proving the identity of the individual who was purportedly supposed to sign.
How long did that take? Do you know?
Yeah. What was that? I'm sorry.
Do you know how long that took? I mean, it seems like a slam dunk case, right, per se.
Well, it didn't take. I don't think that case went on very long, and it was $100,000 policy, which is the highest policy we sell, and the whole policy was paid out with very little in terms of defense costs. They look at that and go, "Yep, the notary is liable here."
And I wonder if there's not the same requirements of proof the way that there is in a malpractice case, where one of the things you have to prove is that but for the error, the person would have prevailed, would have won their case. And there might not be that kind of a requirement for paying off the bond if a malpractice judgment isn't actually required.
Well, I think this issue, and I'm interested, Bill and Chris, in your thoughts on this. I think the issue might become when the bond tries to get reimbursement from the principal, because that's where a principal might say, I didn't do anything wrong. You got it wrong, and I'm not going to pay. So I'm interested to know if that's a heavily litigated area, or there is a lot of reimbursement of bonds.
I haven't seen any litigation on that point. It would be fascinating to see it. I think that our customers generally, if they were found liable in a bond claim of $15,000 plus defense costs of another 15, most would have a very difficult time paying that. We call it salvage in the industry. That's obtaining salvage. The person might declare bankruptcy, or they might not have assets. Some honorably have gone on payment plans, to pay X number of, dollars a month back until, the amount is paid out.
Well, I'm assuming they're motivated because they can't get bonded until the reimbursement is made, yeah?
It's true. And some, at least in the notary world, after something like that happens, of course, you can imagine how devastating that is to be involved in that kind of an action. A lot of them will conclude, well, you know what, maybe I just don't want to be a notary anymore. And they exit the profession, Yeah.
But you guys are all connected, right? You have this database where you check the name of the professional who's trying to buy a bond, right? To make sure there are no existing claims or history of malpractice or something like that.
Privately or publicly?
Either way, to protect the surety, right? The surety to protect themselves. They can refuse to sell a bond, right?
Oh yeah, the bonds are underwritten, which is another interesting point, at least especially on the bonds that I think you're considering here. And Chris could speak to the underwriting requirements, but one of the benefits of a bond over a policy is that it's underwritten. And so, for example, from an immigration consultant, they need to have a minimum credit score, or else the surety will say we're not going to provide the bond, and they may have to go out to a subprime surety, and pay a higher rate for that bond. And so, in effect, by their underwriting rules on the bond, the surety acts almost like a regulator in closing the door into entrance to the profession. If a person doesn't meet their standards for a bond.
That was one of the arguments against
a double regulator process,
Yeah, and typically in the underwriting process, it just depends on the type of bond. So for like an immigration consultant, there's a credit check that surety wants to know what's their likelihood of recapturing any money in the event of a claim or salvaging any money. As part of that application process, the professional signs an indemnity agreement, and they also state on there whether or not they have had any surety claims in the past or been denied surety bonding by another agency. So that's the extent of it. So if somebody lies on the application, that's going to be found out down the road. There's not like a court search or litigation search done as part of the underwriting process. Some of the smaller bonds, like the legal document assistant bonds, because they're only $25,000 for a 2-year bond, there's no underwriting to those at all.
Okay. I think that's a good consumer protection tool, in that if you require a bond and an applicant cannot get one because of their credit history or
right, and the trick will be to try to select how much do you want the bond to be, because the higher the bond, the greater the underwriting.
Yeah, I mean, I'm looking at your immigration consultant bond, and I just answered my question: why is it so high? So, and who sets the number? Is it the licensing authority, right?
The licensing authority will set the limit for the bond, and then the bonds are priced for that particular bond according to what the professional's credit history is. So if they have excellent credit for that particular bond, the premium's $1,250 for 2 years. Average credit tends to price out around $1,700 for 2 years. But then if they have credit challenges or problems with their credit, typically we can get them done for about $4,000 for 2 years, but we've seen some price out as high as like $10,000 because the credit history was so poor.
And you're talking about the immigration consultants at $100,000 ones?
That's correct. Yeah.
And that premium, that bond, a notary bond is $35. So it's really inexpensive. It's hard for the notary to feel they have skin in the game with that. But if an immigration consultant is having to pay anywhere from $1,200 to $1,700 every 2 years, if they've got reasonably good credit, that tells them, I need to be careful,
Except for the notary, even though the premium isn't that high, they have to be careful because they don't want to be on the hook to have to reimburse.
Right.
It out. So I think that's
Correct.
Everybody has skin in the game on that basis.
Well, they do. And it's amazing how many of them don't understand that, even though they're tested on that. It's in educational courses that they have to take and everything. But, there's nothing like a really high premium. Like, when your auto insurance goes up because you've been in a couple accidents or had a couple of tickets, that really helps, make you more cautious when you drive.
It's interesting. There's a lot of issues around credit score, race, access to different mechanisms for addressing bad credit that all kind of interplay potentially.
Yeah.
But it's interesting.
And my understanding is that they're looking at the construction bonds right now are really low, and there's a move to increase that. And I'm just wondering at what point the underwriting really hits. Like if it was raised to 25,000, is there going to be underwriting happen at that level, or would that still be at a low enough amount that there wouldn't be underwriting? But even if there's underwriting, it sounds like the credit score still will have an impact on the premium.
Yeah, typically within the surety world, anything under 25,000 can be freely written without any underwriting. Once they go over that amount, then underwriting tends to take place for the bond. Sometimes it can be as simple as a credit check. Other times it can be a credit check plus they'll want to see a personal financial statement. When you get into some higher price bonds over 100,000, the surety companies can even ask for collateral.
I have a question on notary bonds. So I think it's with notaries that if there's a firm or a company that has several notaries working for it, or maybe this is LDAs, there's sort of like a group rate. If there's 2, notaries or LDAs or 3 or 4, then there's sort of a policy to get for the firm or organization that covers that. Are you familiar with that? And is that something you recommend that we consider, or just focus on individuals?
Yeah, so the only place that I know that has done that is specifically Nevada for their legal document preparers. And tax preparers actually fell within that classification within the last couple of years. So it's become a pretty hot issue for some of these H&R Block type offices that hire a lot of professionals to come in on a short-term contract basis. Originally, that state required every professional to be individually bonded, but now they have created a bond form that allows for a sole proprietorship with just one person. They have a bond if you have between 2 and 25 preparers working for that company, meaning being a W-2 employee. They have a higher limit bond if you have between like 26 and 100 preparers working for that company. So I have seen that in Nevada, and they have scaled that. I mean, ultimately, I think, I'm not sure which way I would probably go on that. I mean, it does make sense to me from a theoretical perspective. If you have a large company that is an ongoing entity that's been in business for a while and you think will continue to be in business, I would be okay with having limited or limiting the amount of bonds they need to obtain. But for certain businesses where they just shut down and disappear after every, call it tax season or every season or every year, you'd probably want to have as much financial backing for those professionals before they provide services to the public.
The only thing I would add is, I think in Nevada, they actually, either in their statute or in their regulations, they clarified this point. So I guess it would be important, whatever the legal, authority is on this, that if you want to go down a group path, that you clarify that.
Do you know if in malpractice insurance or E&O insurance is the credit score taken into account?
Yeah, typically not. Typically with professional liability policies, the applications will focus more on length of time the company's been in business and what their annual revenues are.
Mm-hmm. Okay.
And I know for legal malpractice, it's very complex, and they're all underwritten, and it's the area of law that they're practicing in. Sometimes it's the geographic location. It's a complex actuarial analysis.
What were you going to say, Amos?
I was just saying, and claims made, right? Prior claims history.
Yeah.
Any other questions for Bill or Chris?
No, this was very, very helpful.
We really appreciate your time on this. This is very helpful.
You're welcome. If you would like a contact over at Merchants, we could get you in contact with their VP of underwriting and maybe their VP of claims, and you could pursue any things we couldn't clarify with them.
Thank you so much.
You.
Yeah, and same note, if you have any follow-up questions that come out after this meeting, feel free to just email me or call me.
Great. Thanks for making it available.
Thank you.
Appreciate it.
Welcome.
Okay.
Bye-bye.
Bye.
Okay.
Well, I'm sold on bonds.
It's a lot.
I definitely think bonds, I mean, I'm a broken record on this, but I definitely think bonds is the way to go. I don't think that fully answers the questions about other things like malpractice insurance or a fund, but I definitely think a bond makes sense, and we have to decide on what the right amount is.
And it is a common belief that attorneys have to maintain malpractice. People don't know. You know,
I think I wonder about the credit score impact. Just because there's such a correlation with low credit scores and race. And so you just don't want to create like some barrier to entry that has this disparate impact that you're not wanting to have.
I think that's right, but for licensed professional in California, it's a very common requirement. So notaries, LDAs, immigration consultants, contractors,
maybe it's the amount. Maybe it's the amount of the bond. I'm going to ask Elizabeth if this issue's ever come up, but their bond requirement is low compared to the immigration consultant. But other than that, it seems kind of like a no-brainer.
I think that, so I was wondering if in the credit score, in the credit report, if you lose in a lawsuit, whether that goes on your credit report. I know, like, as being evicted, getting your judgment in UD against you goes on your credit report. So you're trying to rent another place, I think it pops up. I think smile claims judgments go on a credit report. I'm just not sure if a surety bond pays out a claim, then it goes on your credit report. Because I think that's the consumer protection piece is if we require a bond and a licensee cannot obtain a bond, then they're not going to get licensed and they can't perform work. And one of the reasons that they cannot obtain a bond or get it underwritten is that they have lost on other lawsuits or bond claims.
But the other thing that we have to keep in mind is one of the impacts on credit score is like if you just haven't had the opportunity to establish credit. And my children, as adults, both discovered they had no credit record because they had never had any credit cards, they'd never paid any rent anywhere, or even if they had paid rent, they never had any credit cards. And both of my kids went, I have no credit score. And I think this is the issue in communities. And if what we're trying to do is open up a new licensed profession for people who are from marginalized communities and so can't afford to go to law school, if this is what prohibits them from practicing or if it's, and I don't think it would prohibit them, because if there's not underwriting, but there's just the premium is based on your credit score. And if the premium, if it's from the conversation I had, at least with the person who does the construction bonds, it's 1% to 3%. So maybe even 3% of a $25,000 bond would be affordable. But I think that's something to consider. It's not just your actions that lead to having a bad credit score. It's your inability to establish one.
Mm-hmm.
Yeah. Well, I think it's something for us to consider and something for us to visibly consider, include it in the written report. To me, it's not preclusive.
Mm-hmm.
It's like speaks to broader societal issues that we have, right?
Mm-hmm.
You all could consider a bond or malpractice insurance, like you get to choose. One is based on your credit history, one isn't, but the bond seems a lot more protective to me, without any of the consumer, without any sense of, how easy is it actually to make a claim against this bond.
Mm-hmm.
But you don't have to get a malpractice judgment.
Right, and the other thing is that I think that even with a bad credit score, a $25,000 bond is probably going to be significantly less, the premium, than the premium on the same amount of insurance.
Mm-hmm.
Oh, yeah. Yeah. But then the ramifications are worse because they have to pay, if they lose, they have to pay back.
Right.
In malpractice, they don't. I mean, there's pros and cons on both. I just want to, my goal is to either dissuade the bad actors from, wanting this license, or that there's some protection out there for the bad actors who get these licenses and then they proceed to do whatever work they want to do, whether they're competent to perform it or not.
Mm-hmm. Do you want to go back to the slide Linda had up to see if you're ready to make a call on some of this stuff? Or I know there was other proposals for consideration today. So we've got 30 more minutes. Mm-hmm. How do you want to use the time?
Well, can we continue the conversation on the bonds or do we need to wait on that? Because to me, like we've had all this information, mm-hmm. Like I think there's the meeting of the mind that bond would be helpful. It's relatively low cost. So Mike, the next question for me is, how much of a bond? How do we decide that? If there's an agreement that we're going to require a bond. And I don't know if we want to hover on that too much longer. And we've got all this information on this. There's a reason we can't agree to make that recommendation to the larger group.
I would love for our recommendation to the next full working group to include our proposed financial responsibility requirements. Mm-hmm. I hope we're not going backwards on malpractice, because I think one of the questions was, how do they interact? And I think Chris and Bill, dispelled any confusion that there is a conflict of having both, or that there might be double recovery, or that one should come before the other. So if any of those were concerns, I hope that that's been dispelled, because I don't think that's the case. But I do think, I would like our recommendation for the next report to include everything on financial responsibility, and we have a lot of other stuff to cover. So I'm hoping we can move on to some of the other topics as well.
So you're still thinking, Amos, so you're thinking a bond and malpractice insurance and a fee for a restitution fund, all three would be required.
So where I still stand, I don't think I've been dissuaded from my position, is that the restitution fund that's up on the screen that we've been talking about is if malpractice insurance is not required. I think I would like malpractice insurance to be required, but there has been some hesitancy, and I think even if we agree, it may not ultimately get past the working group or the Board of Trustees. And I think there does need to be either malpractice insurance or a restitution fund. I have been convinced from our discussions and our presentations that the restitution fund would have problems with liquidity, with funding, with administration, and so malpractice insurance is probably the better way to go.
But I'm confused by that, because the restitution fund would cover intentional acts, and malpractice insurance doesn't. So they're not. I didn't think that was the either or. It seems to me, from what we just heard, a bond could be an either or with malpractice insurance, unless I'm missing something, but not the restitution fund. And Linda, if I'm wrong, correct me, but I thought malpractice doesn't cover the same things as say CSF does.
Right, malpractice insurance will not cover intentional acts.
Yeah, so sorry, there's this continuing confusion. When I'm talking about restitution fund, I'm talking about a restitution fund that includes errors and omissions and malpractice. Okay, that I think there's some confusion just from the beginning, because we have combined those two to the restitution fund that covers malpractice with the client security fund that covers intentional acts. So sorry if that's a continuing area of confusion. My point is there should, in my view, be either malpractice insurance required or a restitution fund that covers unintentional errors and omissions.
I agree with a requirement of a bond, and I would want to discuss the amount of the bond. I haven't really changed my position on malpractice. I just think that's a good policy, best practice to require for both attorneys and paraprofessionals. I'm just not sold on requiring it. I thought, so remind me, if we include errors and unintentional errors and omissions in the restitution fund, was the problem administration of it and adjudicating, if you would, the claims, right?
And funding it.
Well, funding it would be a fee, right?
Well, but the I don't know how, like, to start it up.
I see.
Yep.
I see.
But
Okay.
the startup fee is going to be an issue for the entirety of the program. I think that what I understood from talking to Heather and others is that when you include the unintentional acts, then you're putting on the state bar as the holder of that restitution fund, their responsibility for proving up that case, just like you investigating, proving it up, just like you would a malpractice determination. And that's quite a bit more extensive than what is happening now, say for the client security fund. So it's the amount of the startup fee, the size and scope of the staffing that would be required. There's a startup fee, regardless, there's startup costs.
So
what is malpractice insurance intended to cover that a bond wouldn't?
Yeah, that.
Amos, why do you think if we have a bond, why would we also need the malpractice insurance?
So that is why I was directing my questions towards that issue in terms of how they interact and is there any conflicts or any inconsistencies. They're two different methods for different purposes and protecting different people. I mean, a malpractice insurance, to tell the truth, might actually protect the professional a bit more because it provides a duty to defend and, could have different limits, but it's very common. Well, for attorneys, what the background is in malpractice, but I don't have any sense of how easy it is to get a claim paid out from a consumer point of view from a bond. I know it's a typical consumer protection that's required of many licensed professionals that's not overly burdensome to require. And as you say, maybe a no-brainer. I mean, for me, this is something that I've said from the beginning, I think should be required. And the harder question is malpractice insurance because it's not required for attorneys. But they're really two different products. So I don't think one deciding on one excludes the possibility. And as you say, it could be an either or, maybe you pick, but again, they're not exactly the same product. So they cover different things or, maybe you do need a judgment to get a malpractice payout. It's just two different products. So I just don't think it answers the question to say a bond is obviously a no-brainer that should be required of whether or not we should be requiring malpractice insurance.
But if the bond protects the consumer and the malpractice insurance really protects the insured, why would we require the licensee to buy something to protect themselves if it's not additional protection to the consumer in addition to the required bond? That's the part that I'm not clear on.
It would be additional, right? So it would be additional because for financial responsibility, right? So for attorneys who decide not to get a malpractice insurance, they are taking on the risk themselves of self-insuring or putting their assets at risk. That's a decision. I think we're setting up a false dichotomy, a false choice, right? So a malpractice insurance, for example, the amounts would be much higher, right? So a typical malpractice insurance that's required when a court appoints a family law lawyer or a probate court appoints, it's mandatory by court rule that they have malpractice insurance, and it's usually $100,000 per occurrence, $300,000 for the policy. And I think that's consistent with what the Washington rules require of LLTs. So first of all, for financial responsibility, it's a much higher amount typically. And it could be higher than that, but that's minimum requirements. So at bottom it does, but again, I don't have any sense that there's not a problem of double recovery. I'm sure of that. The issue is you know, if a bond pays, you know, they'll go after the professional, and then the professional might get paid by malpractice. Again, we can get into that, but I'm convinced that there's not a conflict between the two products. The one issue that was raised, I think, is an important one, where certain exclusions from malpractice insurance may be significant. I mean, and so that raises the client security fund issue. We haven't talked about that in a while, but I think because it's a subset of this restitution fund, but I still think that's a separate issue.
So it sounds like both of you agree that there should be a bond. There's a question of what the amount should be. You both agree that there should be a restitution fund for intentional acts, the parallel to the attorney-client security fund, which would be additive protection, right? Because the bond covers intentional acts. So we would have to think about that. You don't want to have double recovery. But the point of disagreement is, will there be will malpractice insurance be mandated? And if not, will it be unintentional acts be included in that restitution fund?
That's right. And if malpractice is not mandated, are there ways that we can encourage it? I think we were on the same page of that.
About that.
But yeah. I think that, you know, definitely should be encouraged for attorneys too. And also in the disclosures, both in the contract and maybe in other ways, in their advertisements, you know, this paraprofessional does not carry malpractice insurance, something simple like that. I'm all for that. I mean, consumers should make an informed decisions about hiring any professional, you know, and I think attorneys should also disclose that they don't have malpractice insurance, you know, in their but you said they do, right? They have to put in the contract. I don't know if any client will.
But it's very small font. I think we could do a lot better. You put it on the website, big.
Right. That's why, you know, Amos spent a lot of time about the font that they have to use.
I'm just thinking about this issue of the restitution fund covering intentional acts and the bond covering intentional acts. Just something for us to explore internally how that will be handled. But I think we have clarity around where the two of you are, such that this could now be written up as two different sort of proposals.
Right. And really, when we put it to the group this time, and I regret that I didn't make that clear last time, is I don't want to just hear around the room, yeah, I'm for malpractice, or I'm against malpractice. Why? Why, from a policy perspective, again, sounding like a broken record, but why, when it's not required for attorneys, are we requiring malpractice insurance? And I'm totally open to being convinced that we should require malpractice of this group of professional. I want to hear everyone's reasonings.
So can you just expand on that last point, Fariba? Because I think that's important. I do think you might have had a slight change of mind, or you're clarifying your position a little bit, which I think is helpful and healthy. But I think where we were before this conversation about bonds is you were, I think, leaning towards requiring malpractice insurance for paraprofessionals. And maybe even though attorneys are not required to have malpractice insurance. And again, maybe this is the foot in the door for that. Maybe that's a good thing or a bad thing, but I would be interested, because I'm just assuming that this conversation maybe convinced you that bonds might be sufficient. Is that what happened?
So definitely, I know a lot more about bonds, okay? I am not so sure. I mean, I would also like very much to have a restitution fund that maybe didn't have to cover intentional, because the bond does, but would cover errors and omission. But I know it's difficult to maintain, to administer, I get that. And I don't know how much the fee would be for the paraprofessionals as compared to, hey, I'll just get malpractice insurance because it's cheaper. So maybe an alternative, if the restitution fund would cover errors and omission. I know there's a lot of hurdles. There are a lot of hurdles right there, but I'm open to being convinced at the group meeting. I want to hear more input. You know, at the last meeting, people expressed interest in joining this committee, but nobody did. So it's just aimless, and I don't want to go and repeat myself. So, and I know your position, you know, my position, and I'm just
I actually think we might be able to come in with a joint position on this. I don't know if we need to or want to, as opposed to two different, but I think we both, you know, think malpractice insurance is a very good idea. Should at minimum be encouraged, and we really want to discuss at the group level a mandated, and I'm on board with all of that. So we might be able to do that as a joint proposal as opposed to two different. I think where we might disagree, or where maybe it sounds like you might be coming around to this, is if malpractice is not required, malpractice insurance is not required, you know, does there need to be a restitution fund that includes errors and omissions? Because that's sort of my backup if malpractice insurance is not required.
Right, and I'm hearing that it's going to be difficult to administer, and it may cost the fee that we would require. Let's say the hurdles were cleared and we had this errors and restitution fund that covered errors and omission. The fee that you would have to charge the licensees would be so high as to make it cost prohibitive, and they would go for the malpractice. So maybe offer an option.
That's what pushed me over the edge. I mean, the speaker we had that basically said, you definitely don't want to go into the restitution fund business for errors and omissions because of the cost, because of the administration, and malpractice insurance is the, you know, mandating malpractice insurance is don't recreate the wheel. It already exists. You know, it should be required for attorneys. It's unfortunate that that didn't pass, but you're creating a new licensed professional. You know, that's the better option. And I'm convinced that that's right. But we might not be able to, even if we wanted to, we might not be able to sell that.
Hey, sorry if this is a really stupid question. How much do we pay towards as attorneys towards the restitution?
$40.
$40 a year or
a year?
That's it? Okay.
But that does not cover unintentional.
Right.
No. And remember that one of your recommendations, you can say, to kind of address, Fariba, the point you keep making, which I think is a great point to keep making. It could be acknowledging this is divergent from what's required of attorneys, but the group feels that this should actually be required for attorneys, because there's also going to be some reporting requirements when we talk about metrics and sort of data, this proactive regulation type of stuff. That's not required of attorneys either. But you may find that that's something that makes a lot of sense. Like, we should have people reporting on what fees they charge.
Right. So we're starting on the right foot for this program because we have the opportunity to do so, and perhaps take it as an example to make changes in the attorney licensing program.
Yeah, just my point is that it makes you and others more comfortable with that disconnect, because I agree it's a great question to ask. And where there is no rational basis for divergence, then perhaps there shouldn't be. But where there is, then I think it's fine to be explicit about it.
And it may to a certain, sorry, to just my last point is to impact access to this type of profession. And I don't think there's unless you have a rational basis, other than assuming that this group of professionals will be automatically per se more unethical than the average attorney, you know? I just don't want it to come across. We have to have a rational explanation. I'm looking to the group for that.
So I really like what you're saying about, you know, putting that out there as sort of the rational basis. My concern is I'm not sure the full working group will agree that malpractice insurance should be required of attorneys. So if we justify it that way, I'm not sure that gets very far. At least that's my sense of the room.
Yeah, we'll see. There's some loud voices that I think are giving you that sense, but I think the majority may feel differently. I don't know.
Yeah, we're going to encourage participation.
We're getting some new members. Justice Petru, as I know she just emailed us today about another judge coming on. Oh. She's interviewing another public member on Friday. So yeah.
Good.
So do we want to take we've got 10 minutes.
What about the work we did? Well, thank you, Amos. He did all the hard work. I just participated in our meeting, but thank you for putting them down on paper. Do we want to discuss these or I mean, we agree to it. Are we just going to present them at the next meeting?
Yeah, I don't know that we need to discuss them. Well, maybe we should discuss them here because we do want to have it be public, although we did post the document, so it might not be necessary. Maybe just an acknowledgement that you've developed these required disclosures and to include those in the recommendation.
So yeah, and let me just give a brief overview because I think it helps for everybody on the phone or listening in, or maybe if it's recorded for later listeners. The 4 documents, I guess, in addition to your chart that were attached to the agenda, the draft written agreement and mandatory disclosures language, that is really modeled after Washington APR 28G. We did make some modifications. The paraprofessional name is in brackets because I do think, I don't know if it's this committee or if it's the full working group or a later committee really needs to think about the name. I think the name of the licensed professional makes a difference, but we're just sticking in paraprofessional. But you know, this is written agreements and mandatory disclosures and some conspicuous disclosures, really modeled after what Washington did. We also circulated some informed consent language. That is not a requirement in Washington, so that is separate. You know, drafted some language up for that purpose. The scope of practice authorized by the limited practice rule is really modeled after Washington, state of Washington APR 28F. And the draft prohibited acts language is really modeled off of Washington APR 28H. So we didn't take it wholesale, but it's pretty close. And so part of the issue that I wanted to discuss with this group, and particularly you, Greg, sorry to put you on the spot here, is, you know, I had thought we could use the Washington model of they have their APR rule 28 with what, you know, specifically to their triple LTs, but in California, we're looking at, you know, the rules of professional conduct. So I don't know if we want to actually propose these rules in this form, or if we want to take this and then, you know, incorporate them into the proposed rules of professional conduct. I don't know if you have a thought on that, or if that's something we need to sort of study more.
I think we probably need to study that more. We're actually on a staff level starting to go through the rules of professional conduct and identifying the big issues that need to be brought before the entire group, the big underlying policy issues, and in terms of disclosures, that additional disclosures that aren't required of attorneys, trying to decide whether or not those belong in the rules of professional conduct as opposed to rules of court that set forth the parameters of the program and the license itself. So that's probably part of a bigger discussion. I need to look at some of the disclosures that you put together, because I actually, of the 4 meetings that we had today,
I know.
My head is spinning still. So I'll take a couple days to look over those, but I am meeting with some members of the Office of Professional Competence in the coming days to really start putting pen to paper on some of these rules and seeing which rules of professional conduct it makes sense to just bring over wholesale, and there's several, and then others that need to be adapted, new rules. It sounds like if there's additional disclosures that the group wants to recommend, that may lead to you know, new provisions and pre-existing rules and whatnot. So
right. So that's perfect. Go ahead.
But does it sound like you're not looking for, like, it would be premature for this subcommittee to plan to bring, for example, the proposals posted today to the full working group on the 17th? We want a little more time you and Randy at all, to kind of figure out a proposed overall construct and approach, or is it okay for these things to go forward? I think.
Oh, okay. Yeah, that's a good point, Leah. And so I think the policy decisions can go forward to the group. Just in terms of implementing them from a rulemaking standpoint, we probably need to do a little bit more thinking before the staff can make a recommendation. What's the best way to present this? Should this belong in the rules of professional conduct as opposed to the establishing rules for the license itself for the program?
So maybe
I don't see a problem with bringing that forward if you have consensus as a subcommittee on mandatory disclosures that the full working group should consider. Then I don't want to stand in your way bringing them forward, especially since it's these meetings of the entire group are few and far between right now. So get consensus from the entire group on that, then we can move forward on the implementation parts of that.
It's just that some of them these are really detailed, written up as rules. Well, so the meeting is almost coming to a close. There's another meeting on Monday of this group. I unfortunately cannot make that meeting, but I'm wondering if the time can be dedicated to this and figuring out what should be brought forward. Because I think if there's a way to pull out the policy recommendations, and then that is what is brought forward to the group on the 17th, that would give some flexibility, more flexibility than like a specific rule construction.
Yeah, let me look at this and let's take it up at the next meeting of the subcommittee.
It would be helpful to me actually I guess I've attended too many meetings today, but like how to extract policy issues and separate the rules out. So to me, the whole thing should be discussed at the group level and in concept at least be discussed, but I'm totally okay to separate policy from rule and do it that way.
Yeah, well, like scope of practice, for example, there are big decisions yet to be made about whether or not these folks are going to be able to advocate in court and how. So that is probably the discussion to be had. That I'd say is policy, instead of, as distinct from some of the nuances here about, like sub 1A, how you obtain facts, the nitty gritty of that. But the big policy issue on scope of practice is, can they represent people in court or not? Can they take depositions or not? So that's how I'm making that distinction for Reba.
Mm-hmm. Okay. And on that point, I think that's a very good point. This is the cart before the horse problem, or I guess the chicken and the egg problem, which is the practice area groups are still deciding what exactly is going to be done, and we sort of keep shifting which one comes first. So absolutely, I think both Fariba and I would agree that if a practice area decides, X, Y, and Z is what's going to we're going to have to modify this. And in fact, there's at least one big placeholder, because I think one of the things is we want it to be very clear to the client of what the paraprofessional can do and what they can't do. And there needs to be some disclosure of that, or some attachment with a disclosure of that needs to be very clear. But we just can't write that yet because we don't know what so there might be some placeholders, or there might need to be some modifications, which I think we're totally open to depending on the outcome of the other committees.
And scope of practice may depend on the actual specialty they choose also. So
yeah, at least some aspects of it.
Yeah.
The only other thing I wanted to say, we have sort of this hanging item around proactive regulation and reporting, because I think that's a really key issue. It's on the overall work plan for the working group. I talked to Justice Petru about including that on our agenda for the 17th with the full working group. So I hope that's okay with you both. I'm going to try to get a facilitator from the Institute for Advancement of Legal Studies, ILS, in Denver, because I attended a workshop there probably 2 years ago on this topic, and they've been very involved in setting the rules for the Utah sandbox, and to help walk us through like how you come up with what it is you're going to require. So I'm trying to arrange that for the 17th. So I just wanted to flag that for you both.
That sounds great.
So we'll discuss it at our meeting on Monday. We're going to leave it for the 17th, right?
Right.
Okay.
The one comment I'll have on that, because I don't know what the presentation is going to be, is I think it's important to have a evaluation built into this program as well. And it sounds like this kind of proactive gathering of information can be both for different purposes. And I think one of them should be to create some kind of evaluation on the
yeah, I agree.
Impact of the program.
I agree. And you'll see that one of my recommendations will be that the state bar conduct that justice gap study on regular intervals, and the shortcomings that have been identified in the results, that those be addressed. So you've got to duplicate what was done so you have comparative data, but have additional questions that will get at those shortcomings. Because presumably once this is in place for several years, you would expect to see that justice gap come down. That's the whole point. So like at a macro level, that has to be part of the evaluation as well from my perspective. So yeah, I think it'll be a really interesting conversation. All right, this is our last, I think.
No, well, we have one more.
You and me.
Right, not with you, yes.
Not with me.
Right.
Oh, I thought you and I had a check-in at 4:30.
Oh yeah, I'm sorry. No, I thought you were talking about with the
no.
Well, I know I'm done.
Okay. All right. Bye.
Bye. Thank you guys.
Okay.
Monday.